Now, a charge of contempt is not a statutory charge. It's not provided for in any statute. It's a constitutional charge that was enacted in Article 2812, that a court or any quasi-judicial institution or organ or tribunal or a kangaroo court, like the Eron Kiizas want to call it, shall have power to hold people in contempt if, number one, they use menacing words, they are riotous, and they disrupt the proceedings of the court. And in so doing, they can be able to charge you immediately without following the basic rules of fair hearing, sentence you, and convict you. A lawyer should not be subjected. It is a general principle that a lawyer should not be subjected to a humiliation before a court where he is an officer. But then a lawyer must also act with decorum and respect, and fail or avoid as much as possible to approach court stinking with contempt. Once you do that, I think we'll be within the ambits of practicing our profession, representing our clients effectively, and not being injured or being crossfire as a result of our practice and what we do before these tribunals and the courts. But I can tell you that the civil courts have punished Marema Bilizi for 18 months in civil contempt, and the largest person to be charged with contempt is an American citizen called Chadwick. He was sentenced for 14 years. So by the time a court pulls out the weapon of contempt, it has the discretion to pass a sentence and a charge. But I know for sure that we have a lot of backlog in the Constitutional Court, and a constitutional petition once filed may not yield results at all, may not cause the best remedies. If they went to the Court-Martial Court of Appeal, which is the most immediate, which is the most desirable at the time because of the sensitivity of the time. But what I know for sure, Eron Kiiza is going to spend some months and probably serve the full term of 9 months in jail for being held in contempt by the court-martial.